right, I'm happy to call to order public meeting number 109 of the Massachusetts Gaming Commission, this time being held at the Convention and Exhibition Center, convening at 1:30 on February 24th. I think I will turn to our staff, Executive Director Dave for starters, for the first item on our agenda, recommendation regarding review consultant contract.
Thank you, Chairman Crosby. Good afternoon, members of the Commission. We have a staff recommendation actually from the Legal Bureau at this point, so I will refer to Catherine for review of that recommendation.
Good afternoon, Commissioners. You have in your package a memo from me, and basically what the memo describes is that the Commission staff was contacted by attorneys for Mohegan Sun regarding a potential conflict of interest with a contractor that works for the Commission, McFarland Johnson. And as described in the memo, we solicited information both from applicant's counsel and from McFarland Johnson to review the matter. After review of the matter, the legal department determined that McFarland was not in compliance with the terms of its contract. The legal department recommends that the contract be terminated immediately and that McFarland not be paid for work done under Category 1 contract. And we would ask that the Commission review that recommendation and then ask any questions that we can answer and vote on that.
Commissioners?
Well, as I understand it, McFarland had a contract with Mohegan Sun, and in September, I haven't seen any of the correspondence. This is all by my understanding. In September, sent a letter to Mohegan Sun saying.
And was required to terminate as part of our agreement.
I'm not finished, Mr. Chairman.
Oh, okay.
Sent a letter to Mohegan Sun saying that we're not going to perform any more work under that contract. A contract that, as I understand it, now correct me if I'm wrong in any of this, contract that was in essence a put contract. In other words, it gave Mohegan Sun the right to assign various tasks to McFarland Johnson. And the termination date of that contract was 2017. And so it didn't accept any more work after that. It finished some work, some minor work, a few $100s worth of work that it was doing, but it didn't effectively terminate the contract. And Mohegan Sun didn't effectively terminate the contract. And under our expanded ethics rules, Section 10, no contractor or consultant to us can have a contract with somebody else. So technically, they did have a contract with somebody else, even though they'd given notice to Mohegan Sun that they weren't going to perform any more work under it. Do I have that right?
I'm not sure I would characterize it as a put contract because there was ongoing, as I understood this, they had to perform certain functions under at least one part of it during years to come. But they may have been able to take other work as well. It is also true that they did not have the ability to terminate the contract. Only Mohegan had the ability to terminate. Yes.
Right. So I'm not saying that the problem isn't there, but I think the record ought to reflect the nature of the problem. It is fairly clear to me that there was a misunderstanding as to what had happened. The net effect of which was that contract continued, and under our expanded ethics rules, we have no choice but to terminate.
I would say under our expanded ethics rules and under the terms of the contract, because they did not comply with the conditions of the contract.
Right. Okay.
That was the point that I was going to ask for clarification. Was it clear in our contract with McFarland Johnson that they were required to terminate any work for and contractual relationship with any of the applicants that they were going to be looking at?
Yes, and it specifically called out Mohegan Sun.
Because they gave us advice in advance that they were already doing work for Mohegan Sun?
Yes, that's correct.
Would you agree with the characterization that this was a misunderstanding?
I would say the parties don't necessarily agree that it was a misunderstanding. I think, when I look at it, there were certainly miscommunications, perhaps. The termination letter was sent to an individual at Mohegan that no longer worked there at the time the letter was sent. Whether the parties understood that to be the case or not, I don't know. But there was certainly some level of miscommunication between the parties.
Well, I mean, it seems to me, I wasn't quite sure where Commissioner McHugh was going, whether if the point was to make it, that this is really a sort of a technical and trivial issue or not. I'm not sure if that's where you were going. It does seem to me that we have enough conversation about the issues of conflicts and that we are explicit enough in our contracts with our suppliers and with the critical role that these consultants are playing in helping the commissioners evaluate the proposals from the bidders, one of whom the party was still working for. Whatever the intent, and I can't speak to that, it's a big deal. And if it was a miscommunication or inadvertence, that's unfortunate, but it puts at risk both reality and appearance of objectivity on the part of the party. And I think under the circumstances that your recommendation is right. The problem is, and we should talk about this, that it will now do damage if we have to redo the work that they did on behalf of clients with whom they had an ongoing conflict of interest. Then presumably we will have to redo that work, or at least, quality control that work to make absolutely sure that there is no bias. And that's going to throw our schedule out of whack, which we've been bending heaven and earth to adhere to. So for myself, I would certainly willingly accept your recommendation, I think, in spades. But I think we need to talk about what's the impact. Maybe we should talk about accepting the recommendation first, if any other commissioners have any other reactions to that.
Well, I just want to clarify, I'm not suggesting that there's an alternative to termination of the contract. I'm not suggesting that it's not an important misstep, however it came about. But I do think the record ought to reflect the facts, because it is a public process, and it is a public process that calls into account our contractual and other relationships with a firm that's done excellent work for us on the Category 2. So I was just reciting facts, so that the facts, as I understand them at least, are clear. I don't disagree with the outcome.
Yeah.
So the work that gets impacted specifically is relative to Region A. Is that correct?
Yes, that's primarily what's impacted. Yes.
Because we
Primarily?
had,
Well, that's where they did work for Category 1s.
And that's where.
Region A.
That is the impact of the conflict, is Region A.
Yes,
period.
that's correct. Yes.
because we knew about this prior relationship when we engaged them for our Category 2 review, but we had decided that there was no conflict there because the applicants are, well, they're not under contract with those applicants.
That is true, but the contract for Category 2s did have the same requirement that they sever their relationship with Mohegan Sun at the time of the 2s. So we knew there wasn't a conflict, but we had already put that concern out there.
Right, but this only gets to the point that the schedule implication here applies to Region A and solely Region A.
Correct.
Yes, that's correct.
I agree with the legal recommendation that we terminate due to the facts as laid out in your memo.
Anything else, Commissioner? No. Do we need a vote, or do we just need to?
Yes.
We need a vote? All right, well, let's deal with that, and then let's come back to the issue of the impact on the schedule. Do I have a motion from somebody?
I move that we accept the recommendation from our legal department to terminate the contract of McFarland Johnson.
Second?
Is this the one that we currently have for Region A?
Yes,
I want to be clear that what we are terminating.
It's for the Category 1s. We had an overall contract for Category 1.
Okay,
A and B.
A and
A
B,
and B,
And
yes.
C.
Yes, and C.
but not for Category 2.
But not for Category 2. That was completed.
That's right.
Second?
Second.
Any further discussion? All in favor of terminating the contract as recommended, say aye.
Aye.
Opposed? The ayes have it unanimously. Now, what does this do to our schedule? Yeah, just to remind everybody, the plan had been that assuming the worst case on surrounding community negotiations, meaning that the surrounding communities that did not come to an agreement use their full, but were designated as surrounding communities, use their full first approximate month of negotiating with the bidder and their full second approximate month for the arbitration process. Assuming that that worst case scenario happened, our plan to date had been to make the decisions on category A and B, and we're still saying this for B, on approximately the last day of May, May 30th. That would keep the ability to get the license fee from that licensee, since it has to be paid 30 days later, into this fiscal year, which is what the legislature and the governor have been counting on, and we've been endeavoring with all of our might to accommodate. That still holds for Region B. What do we now have for Region A?
So, Mr. Chairman, in your packet, I have a recommendation regarding the schedule for Region A. As was noted, we learned about the potential conflict that impacted our surrounding community analysis. We were trying
Because
to...
McFarland Johnson did some of the analysis that we would have used to make these decisions, right?
Correct, correct. They were part of the team, so they did individual analysis, and then they were part of the team that had conversations regarding what the recommendations would be on surrounding communities for the eastern part of the state. So while we're in the process of completing those recommendations, we learned about the conflict, and it was determined that we couldn't move forward with the Region A recommendations. On last week, February, what was that date?
18th.
The 18th of February. And so in your packet, I have a revised recommendation. The revised recommendation takes into account a couple of key milestones that are forthcoming. Notably, there are a couple of environmental certificates that are being issued and will be issued. On Friday, the certificate for the wind proposal was issued by MEPA, and on March 14th, the certificate based on the Mohegan Sun Notice of Project Change will be issued by MEPA. The comment period for that is due to conclude on March 7th. So given that we experienced the delay, that we were not able to get in the decisions on the 18th, which would have enabled us to get our decisions, as you mentioned, by May 30th, keeping the payments in this fiscal year. What I'm now recommending is, because these other dates are looming or imminent, that would be very valuable information that we could utilize in making our determinations on surrounding community status. And given that both of these certificates are due to be issued within a short time frame of each other, it's my recommendation that we utilize those certificates in making our recommendations. I can't guarantee that what is in there or what is not in those certificates will have a material impact upon the recommendations, but in the past, it has been a pretty important component of some of our recommendations regarding surrounding community status, what we've learned from the agencies and others as part of the certificates.
So the essence of it is, since the McFarland-Johnson problem has kicked us into the next fiscal year, we might as well take a little bit of extra time and get this environmental information, which may be helpful in our deliberations.
That's correct. And as you know, as you mentioned, in all of our scheduling, we had very conservative scheduling. They anticipate that at least one surrounding community or one impacted live entertainment venue will go all the way through arbitration to the very final day. To the degree that the parties can reach negotiations, a negotiated settlement before then, we can issue our licenses earlier.
Right, right, and we'll continue to hope for that.
So with that, March 14th, as I mentioned, that is the date of the Mohegan Sun certificate issued on a Friday. We'll try to get our hands on that certificate on that Friday. Sometimes it's not always readily obtainable on that date, but we'll work with MEPA and Environmental Affairs to try to get that and to do the analysis over the weekend into the early part of the next week. The next regularly scheduled meeting after March 14th is Thursday, March 20th. And it's my recommendation that we make determinations on that date.
When is that? I'm sorry?
March 20th, Thursday, that is the Thursday after the March 14th Mohegan Sun certificate issuance date.
Agreed, yeah. So just carry through what the that
So
one?
I'll take through, so if we make our determinations on March 20th, after the entire period of arbitration and negotiation, after we make our determinations, there's a 30-day statutory negotiation period, and then there is our regulatorily specified arbitration period. If you carry those through the very last day, and then you schedule the hearing, the conclusion of the host community hearing right after the end of the arbitration award, then we could then issue our licenses on June 30th, issue the Region A license on June 30th. That would be with a May 27th end of arbitrations. And so if we issue the award on June 30th, then the license payments would be due July 30th.
Okay. You know, our standards have been that we push to move as quickly as we possibly can on behalf of all the parties who have wanted us to push quickly, but in the final analysis, we don't jeopardize the integrity of the process for speed. And I think reluctantly, you know, I think this is the right thing to do. I mean, I have no reason to think that McFarland Johnson really did have any bias when they did their work, but we can't have a process where that's left open to suspicion or open to litigation. So at this point, we have to let the integrity of the process be the dominant consideration, which means the schedule has to slip. I think we're just stuck with that.
John, can you refresh my memory and help me draw a parallel to Region B? The MGM proposal had the certificate available before we made the determination on Long Meadow?
Yes.
And part of that certificate was the recommendation to study those two intersections along Route 5.
That's right.
Which gave way to our analysis
Correct.
for that determination.
Correct.
Do we expect that there will be a parallel here as a result of these certificates as well? Or do we have information already relative to the intersections that need to be studied and the volume that's expected by the applicants to flow through those intersections? Traffic, of course, being the one that's usually at the top of these discussions.
I'm not certain. I haven't had the opportunity to look at the certificate. I haven't received actually the certificate that was issued on Friday. I do note that one intersection in Cambridge was part of the DEIR filing by the WIN folks. I'm not certain how that's going to result in the certificate. And then similarly, I'm not exactly sure how much of a direct impact the Mohegan Sun certificate findings will have on the two specific communities that we're talking about, but there's a potential that you might get comments that might have an impact on the final analysis.
And the two communities are Everett for Mohegan Sun?
That's right.
What's the second one?
Somerville. And then we have Cambridge and Saugus for the WIN proposal.
I think it's a good recommendation that we have as much information as possible to make an informed decision.
And even though we already have I'm on the push side still for a minute, Mr. Chairman. Even though we already have the certificate, although I had not seen it either, or studied it in detail for WIN, because this is a region that has another applicant, it's important to look at it as the latest of.
Correct.
We would still be in a situation where the schedule slips if only one applicant is forced to negotiate or arbitrate with a surrounding community.
That's correct. But because the certificates are being issued within a short time of each other, and due to completeness and fairness, especially in the light of what we're considering today, I thought it would be a good recommendation to take a look at the certificates for both and make a fair and reasonable determinations based on all the information. And one thing I will note is that for the McFarland team, I've no indication or evidence whatsoever of any bias in any of their reviews. But I think what we're trying to do is be as cautious as we can and make sure that the decisions are fair and just.
I think this is a particularly complex set of interlocking traffic considerations, among other things, and having the opportunity to look at somebody else's analysis before we go forward with ours, I think, given the time span, given where we are right now, I think makes good sense. Makes good sense for the commission, makes good sense for the applicants, makes good sense for the communities affected. So I think it's a good recommendation as well.
Okay, I think we're in agreement. We don't think we need to vote on this. We agreed with the recommendation on the termination. The schedule is what the schedule is. I think we agree with you on this. So we're now bifurcating A and B. We'll go ahead and get B made on the schedule that we've planned thus far, and probably have to slip on A depending on the surrounding community negotiations and the final analysis.
That's right.
Yeah, that's not necessarily so.
Right.
If we don't have to go to arbitration, people can come to agreements and surrounding community agreements, and after our surrounding community decisions, then we don't lose anything.
Right,
So let's
which
hope
is
that
what's
that
happened with all of our other
Everybody else.
Every other surrounding community negotiation has in fact negotiated to successful conclusion and not gone to arbitration. So we may be able to correct this, but we've also always set expectations by assuming the worst case, which is that arbitration takes the full amount of time. So to be consistent, we'll use the
Yes,
same.
I don't disagree.
Yeah, the stakes are higher on the category ones, but hopefully more information on the, like the draft certificate will really help in these negotiations.
Okay. Is that it for item 2?
That's right.
Item 3. Region A surrounding community meetings.
So, Mr. Chairman, that's what we were just discussing, but there's a further item that we have input meetings that we had planned in each one of the areas for their surrounding communities and on our schedule.
Excuse me, John. People should understand that this is not legislatively mandated. There is a legislatively mandated host community meeting held in the host community prior to the conclusion of the evaluation process for each license. We've also added in a second, just public input meeting, which will be held in one of the surrounding communities, just to give us one final shot at feedback from the communities. And it's those meetings that you're now talking about.
That's right. So we had tentatively, and on our schedule that's been posted, we had planned on having our surrounding community input sessions March 3rd through the 5th next week for all 3 of the applicants. But given the change in the schedule, I recommend that we keep the Region B schedule for Monday the 3rd, but that we move the input sessions for the Region A applicants to later in the month after our determinations of surrounding community status. So my tentative recommendation for dates would be March 25th and March 26th for the input sessions for Mohegan Sun first on the 25th and Wynn on the 26th of March.
What day is the host community hearing in Springfield scheduled for?
April 1st?
So April 1st would be our host community public hearing, given our current schedule.
All right.
And that would be the first of at least 2.
What would be the host community for Region A? Host community hearing, the statutorily mandated host community hearing under this scenario.
So those would be later than April. I think that we would need to determine when the first hearing would be, but that we would close the hearings at the conclusion of arbitration, so that we would have the conclusion of the host community hearings on May 30th and May 29th.
Right.
And there's some little flexibility on when we would convene the first public hearings.
So,
The first host community public hearing.
so this is the latest possible date as it stands right now on closing
Closing,
the hearing.
correct.
In order to get the decision made by June 30th.
But these,
No, not June 30th.
June
yeah,
30th.
June 30th.
Yeah, right.
And then for payment by July 30th.
Right. Okay, so that, and that change can be made without doing any further violence to the schedule.
Correct, yep.
Okay, I think that seems fine. We'll follow your lead on that.
Okay.
Well, the other benefit is that the people coming to the community input meetings will have had an opportunity to take a look at the DEIR certificates as well. So there's added information for people to have in hand when they come and tell us about the things they remain concerned about, so.
Right. Okay, is that it?
Yes, it is.
Let's go to item 4, the City of Boston petition.
So, Mr. Chairman, we have two petitions for extension of our surrounding community deadline. The City of Boston requests that we extend our deadline to March 18th from what it was of February 18th last week. Just prior to receiving the petitions, we had internally made our determination that we weren't going to be able to move forward with the Region A surrounding community determinations. And the date that we just decided for surrounding community determinations of March 20th falls later than the requested date from the City of Boston. So given that our date is actually 2 days later than the City of Boston's recommendation, I urge the Commission to take no action on these petitions at this time.
Because they de facto got what they wanted.
Correct. Now, there is some communications going back and forth between the City of Boston and applicants regarding information that is necessary for the full review of the applications. They continue to work together. There was information sharing requests and answers at the end of last week. They continue to work on that. We'll be in communication with both the applicants and the City of Boston to see how we can try to facilitate answers to the reasonable questions.
Well, I think that's really important. This has been going on for quite some time now, and we asked one applicant in the city to come in last fall, and we had a discussion in here, and that led to a conclusion and reaching an agreement as to not substance but status. And I really don't think we can afford to let this run up to March 20 and have problems still outstanding. So I think we need to be prepared to facilitate, if necessary, in this forum, an interchange between the parties to see where the stumbling blocks are and to see how we can break them. And I'm fully prepared to do that.
When would we decide whether to do that or not?
Well, March 6th looks like a good date. It seems to, maybe that's too soon. Maybe we ought to think about a separate meeting. But I think that I've read some of the correspondence that's been going back and forth. It seems to me that, at least in some quarters, they're on a positive track. But I don't think we ought to let it linger much longer. So March 6th is our next regular meeting.
Right.
Maybe that's too quickly, and maybe we'd be prepared to have a special meeting just to devote ourselves to that question.
Well, in what we did last time, we didn't say anything. We just asked them to come in and talk, and that got them talking to one another.
That's exactly right, but we spent a lot of time, as the transcript will reveal, asking for specifics. What information do you need? And listening to the information that was being proffered and asking if you'd given that piece of paper to the other side and asking the other side if they'd gotten that piece of paper. And the result of that kind of conversation produced an agreement. We didn't make any decision, but it produced an agreement, and those kinds of conversations often do. Unfortunately, busy people and thoughtful people and dedicated people sometimes get bound up in misunderstandings, and it's very helpful sometimes just to clear the air by having a conversation with them to help them see where they are and where they aren't.
So we're now scheduled for a surrounding community decision on the 20th?
Correct.
Okay. So we're gonna if they haven't decided, we're gonna decide on the 20th. So maybe the 6th isn't too early. That would, that would.
Maybe I should clarify. Is there still a question relative to surrounding community versus host community?
I think it'd be fair to say that Boston has reserved its rights on host community status. They're reviewing a lot of the information that we are also reviewing in the environmental impact reports and the like, and there's been requests back and forth for information that have a bearing on host community status.
Well,
For both applicants?
Correct.
Yes.
Well, I would be troubled if that was the posture in which this came back to us. We were prepared to have an adjudicatory hearing last fall on host community status or a surrounding community status with respect to one of the applicants in the city of Boston. And that was the agreement that was reached then, and the agreement that I've been operating under ever since is that Boston was a surrounding community vis-a-vis that applicant. So whatever reservations of rights are being made, at least with me, this commissioner, there is an impediment to accepting that reservation. And with respect to Mohegan Sun, of course, that's with the other applicant, Mohegan Sun, it's a brand-new ballgame. So that stands, in my view, on a different plane. I'm only one commissioner, and I simply announced my...
I agree with that, because if that's a stumbling block, then it's a whole other ballgame. We may get to March 6 or March 17 with no better outcome in the foreseeable future.
But we can decide on the 20th. If we decide on the 20th that somebody is a surrounding community or not, it's decided. We don't have to get into whether they're a host community or not if we decide they're a surrounding community.
Right,
So
but
it will be decided on the 20th, one way or the other, as things stand. It's not an open-ended,
fair enough.
right?
And I'm certain that the parties would let us know, I'm sure the city of Boston would let us know of any reasons why it believes that it would be a host community to one or the other applications. And one of the reasons why they submitted the petition was because of the looming deadline on the 18th. And,
Right. Right.
and they understand that we will be making our determinations that even those designated communities are surrounding communities at that time.
Why don't we sort of follow your lead on this, John? You
Okay.
know, I think I agree with Commissioner McHugh. It's much better to get this resolved between the parties if we can. If you think it would be constructive if we had everybody come in and speak their piece and try to facilitate the conversation like it did last time, then let's do that. And the 6th is a good time, but you can tell us if you think it should be another time. But we'll sort of follow your lead on that.
Okay.
You okay with that?
Yes.
I am, and I think the idea is not to be compulsory. The idea for that kind of a conversation is to be facilitated.
Right, right. Right.
Now, learned counsel, Shirley.
Thank you.
Good afternoon.
Good afternoon.
Nice to see you all. Elizabeth De La Russo for the City of Boston. I'm joined today by Corporation Counsel Gino Flaherty, by City of Boston Outside Counsel Bill Kennedy, Tom Frangillo, and Ariel Raphael. Thank you, Commissioners, for this opportunity to present before you. As Ombudsman Ziemba has reported, the city has filed two petitions for an emergency hearing similar to what you're discussing doing on March 6th. And at the core of these two petitions is the city's seeking of information from the applicants, and both applicants. And we do think it is necessary that the commission plays a role in compelling some of the information that the city's been seeking. And we've been asking for that for some time, and I think the time has come that the commission has to facilitate that sharing of information. It's only through this open sharing of information that the city can study these two applicants, both for status but also for impact. So we welcome an opportunity to have that conversation with the commission.
Well, I thought, and I don't oppose that, as you can tell from my earlier remarks, but I thought with at least one of the applicants, a number of documents and papers and things had been delivered last week, and and that you're in the process of reviewing them, or at least have those documents to review. Are those insufficient, in your view, to satisfy your request from that applicant?
So I think you are referring to, on Thursday, the city received some documents from the Wynn applicant, and those documents were, they were not responsive in the city's view to the document request. There was some document sharing. It was redacted, and some documents just remain outstanding, and and that's true for both applicants. And the city really needs to understand the land, the permits, the impacts of the development, and we turn to you now to help us in doing that, which is what the city's job is in protecting the City of Boston residents and the visitors and the business owners. And, you know, yes, we're talking about documents received on Thursday of last week in an ongoing search that's been going on for quite some time now.
Right. Is there a list, a specific list? I saw a list, but it had categories. Is there a specific list of documents that you think are relevant to your inquiry that you have not received?
Yes, and what we'd propose to you, commissioners, is that we can work collectively with Ombudsman Ziemba on a schedule and a process of both applicants with lists, scheduling when the city can review those, so that the city can feel satisfied in its review.
Can you give me an example of both a document and a redaction of a document?
Sure. The city is interested in the permits that are needed and required from the city to develop the two applicants, for the two applicants' development.
From the City of Boston?
Yes, and from the state. We're interested in the overall permits, but certainly the City of Boston permits that are needed. I don't know why that list should be redacted.
Isn't that information that the city could conceivably have?
Right.
The city has
You tell
requested
them.
this information, and it's received a redacted list.
But don't you tell them what permits they need?
Well, under your own application guidelines, you must present a list of permits. The commission has a list of all the permits that are needed, that the applicants need from the state and from different municipalities, but the City of Boston does not have that list. So there's documents that the commission has received that are a requirement of your application that somehow are redacted when presented to the City of Boston.
Okay.
That's one example. Another example of very pertinent information for the City of Boston is information about land acquisition and information about egress and access to the two sites.
So in the instance of the wind discussion, this is not about host community versus surrounding community. This is negotiating a surrounding community agreement.
No, I disagree with that statement. In both applicants, the city does not have pertinent and necessary information to know its status and also to know the impacts on the city, regardless of status.
Well,
So-
what was the effect of the agreement you reached last fall? We were on a road to an adjudicatory hearing to resolve this issue last fall, and you and the Wynn interests said by agreement you were proceeding with a surrounding community agreement and no adjudicatory hearing was necessary.
I think the city and Wynn said in a public statement.
No, in an email to us.
Commissioner, that was meant as a public statement.
Yes. And it's a fair question. So since that time, the city has said that there has not been adequate information sharing to assess impacts or understand status. At that hearing, one of the items that was presented was a site plan, and I think you may remember that site plan. We've asked for information bearing on that site plan, land ownership, access, egress, and that is the type of information that we do not have satisfactory answers regarding, and that does have an impact on the city's host status. It does.
Well, I think that the sooner with your participation and with the applicant's participation and Mr. Ziemba's work, the sooner we can get everybody in here and go through this, the better off everybody's going to be.
Make it
with
the
all due
6th.
respect to everybody. And, you know, these things happen, and, but I really think we need to, even if we have to devote a special meeting to this, we
Well,
need
we
to
have
get this
meetings all
resolved.
week long, you know,
I know, we don't have,
Yeah.
I'm not suggesting we do it tonight.
Oh, I know.
But I do think as soon as we reasonably can do it, we ought to do it.
Yeah, well, that's what I'm saying, we have
Yeah.
meetings all week, so we could do it anytime this week without having to call a special meeting as well as we've got next week available. So, I mean, if, there's a difference, as the Commissioner McHugh mentioned, between facilitation, trying to get parties to talk and share data and so forth. That's what we thought happened with the Wynn Boston discussion last time. There's another, which is to have us make a decision. You know, without some real work, we're not gonna be competent to compare lines of egress and, you know, so what we can do at this stage of the game is what we did in that earlier hearing with Boston and Wynn, which is to try to facilitate people talking to one another and say, hey, don't be silly and refuse to show obvious stuff. If it comes to us having to make the decision, then we really do need our consultants' support and our staff's support so we can make an informed decision. But John, I mean, I hear what, I think the city is saying sooner than later, the 6th is too long. If you tend to agree with that, then if we can tee it up this week, so much the better. On the facilitation side.
Can I make a demur there? I'm all for going as fast as we possibly can. We've got a big decision to make this week, and I would be looking personally, I don't know whether my colleague, whether, I'd be looking personally for the beginning of next week as at the earliest. There's the judgments we have to make this week are in and of themselves filled with work, at least as so far as I can see.
Well, this would just be, whatever, I mean, this would be the facilitating meeting, not the decision.
But Mr. Chairman, I think this has been going on now since the fall. I think we need to be prepared to stay with this for as long as it reasonably takes to figure out what documents are reasonably needed by specific identity, when they're going to be produced, by whom they're going to be produced, in what room they're going to be produced, at what time of the day they're going to be produced, because it seems to me that parties are having a difficulty getting together on those rudimentary things. And I think we ought to be prepared to stay here, if it's necessary, all day. Send people out of the room to talk and come back and try to get to the bottom of this and try to get some basis for an agreement. I don't personally want to be faced, after we've made a surrounding community decision, with a continuing contention that the city is a host community, and vice versa. I don't want to have to avoid looking at some kind of a host community process if we've concentrated all our time on surrounding communities. So I think this is something we ought to be prepared to spend a day on, if necessary, and get people going out of the room with a firm schedule and a firm plan for resolving it, if they can, recognizing that on March 20th, we're going to make the surrounding community decision.
I mean, if we have to do that level of hand-holding, I'd say we should just make the decision ourselves. No, it's silly for us to spend here for a day and, but.
I don't agree that it's silly. I don't agree that it's silly. I don't, well, all right, we have a disagreement, but I don't want to be in this position after we've made that decision with this dispute clouding the process all the way down to the license award, if we can reasonably avoid it. And I think we can reasonably attempt to avoid it by getting into that level of detail.
Let me ask on something that you alluded to, Ms. De La Russo. There's the way you describe the information you need relative to ownership in order to determine impacts, ownership of land, for example, in order to determine impacts. Isn't it reasonable to assume that there's already a lot of information, at least in traffic, whether the land is owned, whether the demarcation goes wherever? Isn't there a reasonable, enough information, more of it coming in this certificate that we're about to get soon, relative to the areas that need to be studied, for example, Sullivan Square or wherever they may be, that where the ultimate demarcation may not necessarily be the issue that decides it?
I think the certificates would be incredibly useful for the city to review. The city doesn't have either certificate yet. One, I understand now, has issued on Friday. We don't have that yet. And then the other will happen in March. So yes, I agree the certificates are important documents to review. And that's why it makes a lot of sense to us to postpone or defer your surrounding community designation upon reviewing those. But I think the point of access and the point of egress to both sites is hugely important to status. And by status, I mean host or surrounding. And that's true for both sites. There is a question on that point of egress and access for both sites, and that has to do with land acquisition. So that's why the city has asked repeatedly for...
Which is what I'm trying to decouple. If you could decouple status from the conversation of impacts, could you proceed trying to determine and negotiate impacts? In this case, traffic, for example. Regardless of where ultimately the egress goes through, isn't it fair to say that the impacts could be studied as far as it remains to traffic, separate from that conversation of host and surrounding community?
I think it's very fact-specific. So in the case of Mohegan Sun, I think you really do need to understand the entrance and the access and the egress at that site, which is, as you know, a new applicant. We studied extensively the Suffolk Downs applicant, but now we have a new point of access and a new point of egress potentially. So you really need to understand that to understand the change of impact. So in that example, it's factually we would need to understand that access in order to understand impact. On the wind side, the city has filed extensive comments on the wind DEIR, discussing where there are factual differences between the study that was done on traffic and the city's own studies on traffic. So in that instance, maybe the point of access is still, I think, still an important piece that the city really needs to understand, but potentially less needed for impact analysis. We're already engaged in impact analysis.
But host community status is a question of geography, not impact, right?
Yeah, this is not an argument of host community status related to impact. This is an argument of two things, bifurcating, as the commissioner said. So the city needs to understand these developments. Point blank, we need to understand these developments. We're missing information and analysis to do so. That's why we've asked to come before you in an emergency fashion to help us and compel some of that information we're seeking. But we also, as a piece of that information, are seeking information that will help us in making that status determination. I'm very pleased to come before you again at March 6th or a separate date. Pleased to work with Ombudsman Ziemba on a schedule of information and how the city can process that information as has been suggested here.
Well, John, do you have a synthesis in view here? You know, do you want to? Go ahead.
I'm sorry. I think the wind interest at least wanted to say something in response.
Okay.
Hello, Commission. My name is Jackie Crum, and I am Senior Vice President and General Counsel of the Development Division of Wind Resorts. Sorry, we weren't prepared today to address or to have an adjudicatory hearing on host or surrounding community status.
This is not an adjudicatory
Understood.
hearing. This is an exploratory probing.
And quite honestly, we had thought that the host community issue was resolved in the fall of last year as well, and that we have designated the city of Boston as the surrounding community. So the question of surrounding community status to us is one that's been resolved, pending, of course, your confirmation that they are actually a surrounding community. With respect to the information request, we did receive an information request in the form of the petition that was filed with the Gaming Commission, and we responded with all non-confidential and non-proprietary documentation. Specifically with respect to the permit request, what we did was we provided the city of Boston with a list of all permits and who they needed to be filed with. What was redacted from that document was the timing that we would be filing those permits. As you know, this has been somewhat of a political process for us, and we're sort of adjusting to this. And we felt that that was confidential information, and we were concerned about somebody using that, frankly, to put up roadblocks. So we had requested confidential treatment of that permit, of that portion of the document with the Gaming Commission staff, and that had been granted. So that is what we gave to the City of Boston. With respect to some of the other requests, there were requests made, for instance, about the profit participation that some of the owners of the land that we have under option would be receiving. As it happens, no one has any profit participation, but frankly, we're not sure what the significance of that information would be to the City of Boston. There were some other requests for confidential information, including copies of our actual option agreements, which, as you can appreciate, do contain confidential information and are subject to confidentiality provisions. But having said that, we are perfectly willing to engage with the City of Boston through whatever forum the Commission would like, including having meetings set up later this week with them, which we do have to discuss transportation and environmental issues. And we will continue to have those meetings and to provide whatever information we can. And if there's a determination made that we are not providing information that we should be providing, we're happy to provide that information.
Can you help us understand a little bit if confidential information is at least part of the sticking point? Is it something that you could facilitate, for example, you are the custodian of that information, the unredacted version. You could have perhaps, and I may be speaking on a term here, but have both representatives from the applicant and the city come observe that information, whatever may be relevant to them. I understand the argument about relevance, but is it possible that they could come to your office and they can observe certain pieces of information that may resolve some of these?
I think if the applicant is comfortable with that, we can certainly work on that. You know, we granted confidential status in accordance with our statute and regs. If the applicant was amenable to having it available in our offices for the city to review, we could certainly set that up.
But that doesn't really speak to the issue of the applicant.
Well, baby steps. You know, maybe there is a little bit that could facilitate. I mean, I'm not suggesting everything might be. I understand the argument about relevance, but just a thought.
As long as we're here, you know, can you enumerate any particular things beyond the things which have just been addressed that you would like to have, that you think you need, that you don't have from WIN?
Certainly, Commissioner. I think we have presented a lengthy list of documents. This has been going on since July. We have kind of a long back and forth correspondence. And I brought with me here today a couple of those document requests. We've put a couple of them in front of the Commission already in the form of our latest 2 petitions. Permits remain incredibly important. I like Commissioner Zuniga's idea that we could go to if there's a concern of the city holding these documents, we could go to the Commission offices and review those.
The issue isn't permits. The issue, according to Ms. Crum, the issue is the dates at which you expected to get them.
Right, the timing for applying for them
So
and when they would be granted.
Is there some reason why, are you contesting that?
Yes, we have a list of for the permits that just says, you know, permits needed, City of Boston, Boston Transportation. We're looking to say, well, what are the permits? What are you talking about? What is the work that's being done that you need these XYZ permits?
So, and there's a disconnect.
Actually, no, I apologize, we misunderstood that request because that was never set forth. The Commission doesn't have any additional information that the City of Boston does not have. That was not contained in our application either. The only thing that was redacted from what we provided to the City of Boston was just the timing.
Well, see, this is why, with all due respect to everybody, I know everybody's been working very hard, and this is why I think we just need to have everybody here and either broker a deal or go through that list and say, give them that or don't give them that in exercise of our power and get this done.
I really object to that. I mean, we'll do it if we have to, but I think that's absurd for us to have to sit here and have to do that. So, I mean, I think you get the gist. I mean, take this one example, there's some disconnect, and if you set aside the emotions and the history and the prior politics and so forth, and just try to figure out what is it that you really want, and can you give it to them, and you sit in a room with people like Council Kennedy, whom I would have confidence could take a deep breath here, then I can't believe you can't get this done. If we have to do it, we will, but it's preposterous for us to spend our time to go through that kind of a list with you. So, but I would take a crack at it, maybe send somebody new into the room. Welcome aboard, Councilor Flaherty, O'Flaherty. But if you can't get it done, we'll do it, but it's ridiculous.
As I mentioned earlier, we do have meetings scheduled with the City of Boston this week, I believe on Wednesday and Thursday, with our traffic consultants and environmental consultants. And we remain hopeful that that will get us through yet another step, and that hopefully we can then narrow down the field of documents that are still outstanding, if any.
Commissioners, thank you, and I agree with Attorney Crum. We're happy to work collectively. We just think at this juncture, we ask for your involvement. I just want to point out that beyond the applicants, the city has made requests of the study of impacts to a neighboring municipality in the city of Everett, and that is long outstanding as well. So we are looking beyond the applicants to say, other municipalities, how have you studied this? Can you explain the land? Can you explain the impacts? Can you explain any piece of these developments? And we're still waiting for those. So it does go beyond the applicants. And I would add...
What authority do we have to start ordering cities and towns to produce things?
Well, the city has engaged in a public records request to the city of Everett.
There's a forum for that, but it's not this.
I just pointed out this is beyond the applicants. I would add that what the city is trying to do here is understand these developments. It's that simple. There's not a nefarious purpose behind this. It is to understand these two applicants and to be able to assess impacts from those applicants.
Well, there's how many surrounding communities around Springfield that already made an assessment as to their status, and they also they had all the information they could reasonably get, and there was, I'm going to guess, at least some assumptions of the future, just like all these studies. All these studies present assumptions of the future, and they were able to reach a number of agreements. Some of them with some contingencies, some look-back provisions, and etc. So I think if anything, they provide a great example as to the ability to get to a resolution in terms of an agreement about information that may be imperfect. I don't know where that leaves us, but I just want to point out that it can be done. These are rather large and unique in many ways, but they're not something new in terms of the type of traffic and construction that they bring to a city. There's been a lot of development in the Longwood area, for example, that I would equate, I go through every day, and I would equate some of the impacts of all of those, all of that construction that has happened over the last few years may have a parallel to what could happen if a casino came to the city of Everett or Revere.
I agree, Commissioner. The city of Boston does large-scale development every day of the week. You know, the city knows how to study developments, and we're trying to do that same process here. There's nothing unique about documents or information the city's looking for. This is the information we need to assess big development.
Except respectfully, our development is not within the city of Boston.
Okay. We're not going to get anywhere there.
No, but I think you get the drift. The body language of the commission is suggesting that this is an unbecoming conversation and shouldn't be necessary. Although we all appreciate all the different issues, believe me, we all appreciate, all the passions, but it's nevertheless unbecoming and pointless. And if you all can find a room and people to talk to one another who can resolve these issues, great, get it done. If not, John, tell us when we need to do it. You know, if it's the 6th is soon enough, fine. If it needs to be sooner, but just let us know.
Thank you.
Thank you.
Okay.
Thank you.
What's next? Draft license award with conditions.
Commissioners, in your package, you have a revised draft of the license.
Break besides.
Go ahead.
Okay. We're going to take a very, very quick break. Right back, don't go too far. Are picking up again at 2:35 with item number 5.
So Commissioners, in your packet, you have a draft form of the license with conditions. This has been redrafted in accordance with our discussion at our last meeting, as well as with a review of all of the comments that we received from applicants and others. You will see that it is set up in a decisional and comparative form. It will track, hopefully, the findings that the Commission makes as it goes through the Category 2 reports. We will incorporate them into this license form once the reports are completed and the decision is made. We've taken out the laundry list of conditions that were from the statute, and we've simply required compliance with the statute and the regs. And then we've added a few other non-statutory provisions that were both suggested to us and items that staff thought should be included.
Okay, questions, thoughts?
Catherine, a couple of quick questions. How do we reference or suggest to an eventual licensee those terms in regard to their compliance with what they've promised in the application?
Those would be under the section that's for specific provisions, and
Okay.
we would make specific reference to things that they provide to us, such as timelines, construction schedules. If they proffered particular types of activities, we would put that in the specific conditions portion.
Okay. I mean, I have some, coming out of the discussion with the folks that help me evaluate economic impacts and some suggested conditions, you know, with respect to tourism, with respect to working with various state departments, with respect to working with our gaming vendor resource team, complying with the MOUs that I believe all the applicants signed with the Mass Community College Casino Career Training Institute, things like that. Where can we find room to put those in without kind of adding them onto the conclusion conditions?
Well, they would be best added onto the conditions section. They could be added into the general conditions section as they, may be applicable to all applicants.
Okay.
But if there are specific items that fall into those categories that you would like a particular licensee, the actual successful licensee, to comply with, we would put them in specifically and relate to that licensee. But we can do some of these in the general overall conditions as well.
Okay. Because I do have some language that I played with respect to just some of those provisions. So somehow I'd like to find a way for them to find their way in the license. The other question I had, and you referenced it, on page 4, item number 17, which I know is taken directly from the statute, and that affirmative action program is referenced later in the statute under section 21. What I wanted to suggest is that, I think the language provides that they offer an affirmative marketing program for our MBEs, WBEs, and VBEs for design and construction and ultimately supplier vendors during operation of the facility. I guess I have a worry that unless we put some timelines in for those plans to be in front of us, because they all require commission approval, that they do that within a short time frame. I mean, some of these folks have already engaged people to help with design. They're already looking at construction. And I worry not having a timeline attached to those provisions, whether it's 30 days, 60 days, whatever it is. I want to make sure that they know what their obligations are. We're not waiting around. We actually miss a boat during this design and construction window. Similarly, in Section 21, subsection 22, they need to come up with the affirmative action program for minority women and veterans to be involved in the construction process. And again, there's no time frame either provided in the statute, but I want to enlist some type of time frame that's amenable to all parties, that fits within their obligations to us, and how quickly we can review that plan, because we don't want to slow them up in design and construction once the license is awarded, but I don't want to put the commission behind the 8 ball in terms of our responsibilities either.
I think we can add timelines here, and it makes sense to add them in that this is an issue that we would address in the regulation that we're looking at regarding pre-construction and monitoring.
Okay.
But we are not far along in that process to have gotten comments and incorporated it into that regulation. So since we are where we are in terms of the license decision process versus the regulation that might address it, it makes sense to me to put some timelines in the license itself for the Category 2. By the time we get to the ones, we will probably have some timelines built into the regulation that may address that. So I would be comfortable with putting in timelines that the commission felt acceptable into the license form to address your concerns.
Okay.
Thank you, sorry. On page 5, I see that you have, in this form, I'm particularly thinking of the finance section, for someone familiar with it. Effectively, what is our sub-criteria and criteria? And you have boxes here. Is your vision or your recommendation that we will have the ratings or the summary of statements or full statements that we have behind each one of these?
I think at the finance section, when I was looking at the templates, I think I actually have too many criteria in there. I have the sub-criteria. So I think what we will do in the finance section is go to the broad criteria, and we will have the descriptions that come out of your reports of each applicant from that particular section. I have, I think, too many, quite frankly, too much detail in the finance section, so I want to sync that up to the reports once they're finalized.
Because you have 4 criteria, right?
Yes.
Yes.
And did you match that?
That's what I would like to
Go with the criteria.
I have too many now. I have, I think, all 11 of your
Sub-criteria.
questions. Yes, and I will cut that back to the 4 criteria that you have.
But it's not just simply the rating. It's all the discussion that happened
Yes.
that we'll be getting into tomorrow.
Well, that will be here, not in these boxes.
Well, what comes out of the reports will be in the boxes. The discussion will be a little bit in more detail, the comparative discussion as to why the commission thought one applicant over another maybe had, a better position in a particular group. So it'll overlap to some degree.
Right. Okay.
And are you just, in your mind's eye, the overview, the 5 sections, the comparative discussion, are you talking a little paragraph? Are you talking a page? How do you anticipate doing that?
In the 5 sections with the tables, I'm thinking of a
Not the tables.
Oh, in the
Those are-
overview,
In the comparative discussion, section 4.
it could be a few pages, hopefully not, but, a page probably to cover all 3 at a minimum, a page or 2. And that will be based upon the commission's discussions as to the various merits of each applicant.
And this presumably will be passed by us in draft, right?
Yes.
Okay.
Well, the statute, section 18 says, we have to issue a statement of findings on how each applicant proposes to advance the following objectives. And then follows the 19 objectives that are on pages 3, 4, and 5. Where is that statement of findings on how each proposes to achieve those objectives?
The objectives of the list that comes,
Section
section 18,
18,
yes, the section
says-
18 objectives.
in determining whether an applicant shall receive a gaming license, the commission shall evaluate and issue a statement of findings of how each applicant proposes to advance the following objectives. And then there are these 19 objectives that are listed on pages 3, 4, 2, 3, 4, and 5. Where does that?
My hope was to address that in the tables, along with the discussion of what you found for each particular criteria.
But for example, if you take number 8, there are 6 subparts, or 7 subparts to 8. I mean, it's how would you do that in a table?
I would take that information out of the reports that you generate. The table will be large. It's going to be, it'll be a larger table for something like that.
But I think what we're doing, we've got the specific wording of the statute calling for, you know, how the findings, how each proposal will answer the 18 questions, the 18 points. And then we've got a little more broad sort of functional plan that we want to write something up that is reasonably describes to a reasonable reader what our thought process was and how our analysis was concluded. They don't fit exactly, but maybe the easiest, but I think the latter thing is what really matters. You could accomplish Commissioner McHugh's point by incorporating their applications by reference, because they did it. You know, that's the applicant saying how they plan to address those 18 issues. That takes care of the statutory requirement. And then let you and us go ahead and have a more kind of general, functionally based conversation in sections 3 and 4 of our conclusions.
Well, in addition to that, you know, I'm just looking at number 3 here, which is an easy one. The reference for realizing the minimum capital investment, you know, yeah, maximum capital investment is, there's a section in the finance section that's very discreet. I know it, we worked on it. If anything, our regs helped us arrive to it. So there's multiple references, not just that exist, not just whatever the applicant submitted. In other words, information that we created, analyzed, and therefore are finding, and then, in my view, complies with that requirement of finding of facts.
Yeah, sure. I just was wondering where we're going to put that.
I mean, we don't want to rewrite an 18-question, 3-person chart where we try to recapitulate everything that they said and put it back in there. But we do have to comply with the rule, with the law. So, I mean, I would think the easy thing to do is to get rid of that sort of literal and technical requirement by incorporating the applications. And then use the findings, section 3, which is, gathering pretty, is your number, is the very good, excellent, insufficient? Or are you planning on having more in those?
I was going to put in the description, the narrative description that we have for each of the criteria for each of the applicants, yes.
Yep.
So you'd have the very good and the bullet points, or however we've done it in our.
Yes, that would be the information we would incorporate.
Okay.
Well, it seems to me that information, if we're going to take that out of these various reports, combined, will answer all of those 19 questions. I mean,
They
we've
should.
addressed all of those 19 questions
Yeah.
in various forms in these reports and the presentations. I don't think that they have to.
Excuse me, except what's going to be in section 3 is findings, which is our interpretation, our judgments. It's not what the applicants put forward necessarily. I'm okay with it if you are, but I thought.
We're supposed to make findings, Mr. Chairman.
Right.
Findings on how they propose to do it. And I think the legislative intent was to make a finding, not simply to accept whatever they said. And it seems to me that the process that we've been through is designed to test what they've said and see if it's realistic.
If you're good with it, I am. That's fine. I thought you were taking a different approach. So.
No, I just wanted to know where it was, because I assumed, and now I understand I'm wrong, I assumed that what's on 5, 6, and 7 would be those sufficient, insufficient, very good, outstanding.
Not just alone, no.
Right.
No, there would be the paragraphs that go with them.
Okay, fine. Are we cool with this? Everybody else?
And then the particular conditions could go in, did I understand you correctly in response to Commissioner Stebbins' question, in and after paragraph 9 on page 9?
Yes, that's correct.
Mr. Chairman, that's a particular area we seem to still have some confusion on as to how the commission will address conditions in the process tomorrow.
Right.
So we've tried to explore that and see if we can come to some determination as to how the commission might want to go about that. I guess there's several options that have come forward, but I think the big part of the discussion is does the commission want to take consideration of as we move, let's start with the first day, as we move through the reports, the concept is that the commissioners may choose to make the presentation, also make some recommendations per applicants. As they move forward.
Recommendations for conditions.
Conditions, thank you, sir. As we move forward through that process, the thought is that staff would record those conditions just to keep track of it. As we got to the end of the report period, staff would then come to before the commission. We'd review what conditions there are. The commission may very well have a discussion about whether there are other conditions. At some point, at the commission's request, if these conditions were something the commission wanted to move forward, we would visit with staff or with the applicants about it and come back before the commission to have the applicants specifically discuss any conditions. Lastly, is that one of the conditions that are in this final decision is payment of fees. From the staff.
You're talking about the one-time license.
License fee, yes. Payment of the one-time license fee. From the staff's perspective, we were thinking that and that's the way this particular document is designed, is that would be a condition once the final decision is entered, signed by the commissioners, and it would be in the final decision that they have to make payment according to statute and regs, the regulations which provide the exceptions that the commission recently approved and adopted per emergency regulation. So that's, there are different options. A commission could talk about all the conditions right at the end. They could do a combination. There's all kinds of varieties, but we thought it would be important at least to discuss that with the commissioners today before you actually get into your reports and then have to face whether or not what you're going to do with the conditions.
Along those topic, I had a question about conditions. For example, if the applicant has already agreed to, let's say, protect and enhance the lottery, as an example from mitigation. They've already have an agreement with the lottery, a signed agreement. Do we then have to make that a condition? I guess my question is, if they've already agreed to something, then does it have to be a condition?
Well, in that instance, that's a condition that's required by statute, so it's covered by our overall compliance with 23K and all of the regulations. So you wouldn't have to do it again.
Then on top of that, say at the end of my presentation, that's one of the conditions, because it's already covered.
That's correct.
Is that correct?
Yes.
It's correct that she does not have to say that.
She does not have to say that again.
But wouldn't a reasonable condition be that they maintain and comply with the contract that they entered into?
And we have that in this license now as a condition, with all of the host community agreements, surrounding community agreements, ILEVs, lottery agreements, and all federal, state, and local permits.
It's number
So
6.
we do have that. I think an example, to follow your example, where you might have a special condition is if as part of complying with the lottery agreement, they had some special situation that they agreed to, that you felt was appropriate to call out, we could put that in the specific condition section. So if there were some special agreement on lottery machines or something that was unique, we could potentially call that out. But if it's just to comply with the terms of the lottery agreement, you would not have to call that out again.
Okay. Thank you for clarifying.
Some applicants entered into agreements like neighboring community agreements that are not a designation of a surrounding community or an ILEV or would those fall on, would any of those fall under the specific conditions, or could we just incorporate broadly in the form of license here on number 6?
I will add that to number 6 to cover other community agreements.
as a practical matter, I've imagined that these conditions, of which we don't know whether there are any, this is just speculative, but if, for example, we felt that there were too few parking spaces, and we felt like everything else was fine, we pick you, but that feels to us like too few parking spaces. Might that be a condition that we would discuss and then add in under 9? Is that the kind of thing you're talking about? Something which is, I mean, we're obviously going to hold them to the commitments they've made, that's clear. But are you talking about anticipating the possibility that there might be additional things like that which are not part of what they have previously committed to, but which we, in our power to negotiate, would add?
I think that's possible. I think more likely it would be issues that came up in your review of their applications where you found something that you thought needed to be addressed, or perhaps the professional consultants came forward with a
But
recommendation.
Like what, for example? How's that different from more parking spaces?
Well, I think more parking spaces is one, but I think there may be, I would think that probably came up in the review discussions, and that's how that gets raised. It's something I think the commission probably would have considered as part of the evaluation. But there could be other issues that the commission discusses and decides as a commission that you would like to see.
So it's basically number 9 is other things. It says, I mean, other issues, it's commitments we want from them that they've not already made, but we consider preconditions to the award. And it's pretty open-ended. We have pretty broad authority. We've said repeatedly, we have the authority to negotiate here, just like, they compete with one another. We can add in terms too. So if we wanted to add in terms, we have that authority, and that is the kind of thing that may previously have arisen out of the suitability assessments or might arise out of our conversations over the next few days, our evaluations. So, I mean, okay. So
Yes, that's correct.
It gives us, make it clear what we're talking about, but also gives the bidders notice that we consider it within our authority to add preconditions.
I think, Mr. Chairman, there's actually kind of 3 different types or kinds that may come up as conditions that came up as a result of each commissioner's review and that they would recommend move forward. Something that comes up with during the discussion as well. And then when we actually talk about discussions at the time, the commissioners may decide at that point that there's some other special condition that they might want to impose on the applicants. So it could be, when you're all done, we might be wasting our time speculating.
Right.
There may be no conditions,
Right.
but at least we're trying to postulate where that might occur in the process.
Okay. Now, you started this off. You want to go ahead on this? So does that clarify what you
It does clarify for me that I do not, I know, for example, I will not have any additional conditions because they're all covered in one of these categories, 1 through 9. Regulations, signed agreements, ILEVs, host and surrounding communities. So I'm clear on if there was anything additional I needed to do to be prepared, and that's covered.
But you understand the nature of the kinds of things we're
I do,
talking about that
yes.
could conceivably come up. Okay, now there's a second step. So I think we're all clear on all conditions but the last one, which is a condition here of paying your license fee within 30 days of the award. And if I understood what you're saying, and maybe I didn't, what you're suggesting is that prior to the final award, the staff, if there are anything under 9, will have gone back to the bidders and said, before we make the final decision, we just want to make sure that you're okay with what's under 9. And you will then report back to us. We will then make our final decision. Am I right about that?
That's correct. We
Okay.
would go to the applicants, we would have a discussion, we would explain those, we wouldn't be in a bargaining position at all, and then
Yeah,
both
they will.
applicant and staff would come back to the commission.
Okay. Then, if I heard you right, you come back to us, they accept or not, we then make our decision, we have a vote, we make an award. That triggers the award. One of the conditions on the awarded license is the payment of the license fee within 30 days. You then take that agreement to the parties, and if a party says, I don't want to pay that $25 million, then they come back to us, or they have the opportunity to come back to us and say, I don't want to pay the $25 million. Is that right? and then we discuss the various options, maybe, and then we then decide whether we can move on to number 2, or whether we discuss options for dealing with that. Do I understand that correctly?
Actually, it's slightly different, at least from our, that's a possibility, I think, but what we were suggesting is that the question of fee payment actually be put in as it is in this, which is a condition for the licensure award, whatever we want to call that. That will actually be issued at a separate time up to the licensee. They would come before, they would request hearing before the commission and come before the commission on that subject or any other condition they were coming before, but most likely it would be on that subject. At that time, the commission could listen to what they had to say around why they couldn't pay the fees or what other suggestion they have, and the commission would decide accordingly.
Right. Okay, but the requirement for the license fee is in here now.
Yes.
That's already in there.
Yes,
So
it's
that's
there now. Right.
That's what the award is assuming.
It's
Yes.
assuming that the payment will be made within 30 days of the issuance of the award.
Okay.
Yes.
So we make the award, 30 days starts to run. If a bidder, this round or another round, on a license award winner says, I don't want to pay the license fee, they come back and you're saying, I gather, Counselor, that we can implement our various, we could consider the various options we've given ourselves under the regs, which would be to extend the 30 days in various fashions in that scenario if we chose to.
The applicant would have to, the successful licensee would have to come back and explain why they couldn't comply with the license. And we've then moved into a situation where the commission can determine what it does with that license. And it could consider the alternatives that it has under the regulations, if it chooses to, in terms of how to address the applicant's concern. But the applicant, the burden would be on the applicant to come back and explain why they can't comply with the terms of the license.
It seems to me that we're in a very tricky ground if we do it that way, because the statute says pay within 30 days of the award. We've made the award, we've said 30 days, and now it doesn't seem to me we have all that much leeway to implement those other things we created.
Well, I view this as the determination of an issuance.
Determination of a what?
Of the issuance of an award. So I view this as the commission's determination that they will award a license. How the commission proceeds with that.
When does the obligation to pay arise if we haven't awarded the license?
We are going to take the position that it runs from this term, but that's something for the commission to consider as they are working through their reports and looking at what determination they want to make.
What if we decided that went all the way through this, made a vote, and said we're going to vote to award the license to X on the following conditions, the statutory and any other special ones, and gave the staff then time to talk to the applicant and say, is there anything about these conditions that troubles you? And if there is something that troubles you, go in tomorrow, you got 24 hours, you go in tomorrow and talk to the commission and let the commission hear what you have to say, and then we haven't done anything then. And then talk to them and see if A, we accept their concerns, and B, if we have a remedy for them. And then make the award. Up to that point, we've just signaled an intention to make an award. Nobody can possibly argue that we're blocked in by the 30 days. And we have time to negotiate, which was what we spent all the time doing, setting up our negotiating room, particularly around payment of fees. What would be the downside of doing it that way?
I think the commission can certainly do it that way. I think it's a question of what kind of conversations and conditions there are with that particular situation and what the conversations look like. But I think from a process perspective, yes, the commission could do it that way.
But I'm not sure I understand that point, because the conversation could be as simple as, do you have, to the applicant and staff, do you have any problem with any of these conditions? Yeah, we don't want to do X, Y, and Z. We don't want to do some statutory thing that we haven't even thought about, regulatory thing, and you explore that a little bit and say, well, we can fix that, or you'll have to go back and talk to the commission tomorrow about that.
Well, that was what Executive Director Day proposed in terms of all of the other conditions that might be under Section 9.
Right.
We hadn't added the condition under Section 1. We can certainly do that and have that conversation as well.
Yeah,
I
it
mean,
seems to me we ought to know all the conditions. Yes. If they have any problem.
But up until now, we had been bifurcated. We had a plan in place where all the Category 9 conditions would be addressed before we made our decision, before we start the before we make our final decision, but then we make our decision. Because we were bifurcating the number 9 from the license fee. And I like that, I like it being clean that way. I want to keep the license fee as far away from our evaluation process as we can. But it sounds like you're putting them together again.
Yeah,
And
but-
all conditions would be looked at the same time, which is right at the very last minute.
But it's only after there is an apparent successful bidder.
Well, after we've made it, the problem with the apparent successful bidder is, I'm not sure how we know there's an apparent successful bidder unless we say so.
Well, we call it the
Yes,
vote.
we call it.
The reg says the vote.
We have the vote.
Well, but I can turn to each of you and say, do we have a consensus? I mean, before we vote, the problem here that I think you're addressing is the same one I was addressing. Once we vote, we start the 30 days, the way things stand. And I'm not sure we have the ability to undo the 30 days. But if we have made it clear where we're leaning, but then we double check on the license fee, and then if they say no, we come back and talk. If they say yes, we vote and go forward.
Well, okay, I hear you. Whether or not we have a formal vote, I don't think we trigger anything by saying we intend to award you the license if, on the following conditions. If you accept the following conditions, we can even say that. And then you have that discussion. They either agree to them or not agree to them, or we work things out. But then we have the vote saying, okay, you got the license now on the following conditions as originally stated or as modified by our discussion, and then the 30 days begins to run.
Right.
I don't think anybody can argue that.
No, I'm agreeing with you. The only thing is, you're
I'm putting things back together. I guess I am.
Right,
Yeah.
so you're
Yes, I am.
saying, we add up all the conditions, whatever they
Right.
are, we don't know whether there's gonna be more than
Right.
9 or not.
Right.
And then we don't have any conversations with anybody until we get
Right.
right to the point of
Right.
saying, we're gonna pick such and such as long as they go forward with the conditions. Then the staff talks, and we see whether we have any issues or not, before the vote is taken.
I think that's much cleaner.
That was,
I didn't like the idea, or I couldn't visualize the idea of trying to stop our deliberations in order to have you go talk to an apparent successful, I just couldn't envision that, and I like this method.
Well,
that-
we're still, just to be clear, that is what we're doing.
Yeah.
No, but we've said this is the successful bidder. We've said that. We haven't voted, but we say that. Is that what I'm hearing?
Yeah,
Okay,
subject to these, whatever the conditions are.
Correct, but before we weren't going to,
it's a labeling thing. I mean, this is a clearer label. I guess maybe that's the only, it's a
Well,
clearer label and a clearer.
Maybe we should just drop this if we're close, but just to choose my example of the Category 9 condition of too few parking spaces. What I thought we originally were talking about is, okay, all the evaluations have been made, and somebody has recommended that there ought to be that more of the parking spaces for applicant A. It would be good to know whether they were going to agree to the more parking spaces prior to us deciding which one we pick, because maybe we wouldn't pick them if we didn't know about the parking spaces. However, if everybody else prefers it the other way, I'm fine with that. So we lump them all together.
And I hesitate to add anything to the discussion further, but I think part of what we were.
Angels fear to tread.
Yes, part of what we were contemplating is to try to keep all the applicants involved during at least the first half of it. So we would take not only the apparent, we didn't know the apparent successful, and we didn't know anything about the fees yet. So as the commissioners reported, we would be collecting the conditions. When we got all that process done, we would talk about all the conditions with the commissioners. We would then go review those that apply to each one of the licensees, so not we're not identifying a separate or an apparent winner at this time, and then we would come back. From what I hear, what the concept is we won't even mess with, we'll just, the commission would continue with the report and the deliberation, and when you were at a point where you thought you had an apparent winner, essentially, we would then contact the applicants and address the conditions with them to include the fees, license fee issue, if that's what
I was with you on the earlier one, but I'm happy to go the consolidated way if that, if everybody prefers that.
Consolidated?
I do prefer that.
Okay, we've got that, right? Now?
After the tacit winner, pre-vote, all conditions.
Yes,
Yes.
good.
Got that, Jackie? Tacit vote, pre-conditions, right.
I have one other little matter that just, it's kind of fill in the blank thing, is the period of licensing isn't it isn't specifically attached or defined in the statute, so we wanted to recommend to the commission it might be good before you start in your process tomorrow to clarify to the licensees what the period is going to be. That's the 5 or 15-year period by when it's going to start. At least from staff's perspective, and I think what we have understood generally is that that period would begin with the approval of the operation, temporary or permanent, by the commissioners. That seems to be a good place to start that period, the 5-year period or the 15-year period. If that would be something the commissioners would be interested in approving, I think it would be helpful.
Well, I think that's a good recommendation. At least I always assumed that the period of the license included the 15 years and the 5 years included only operations and not, say, permitting and construction. The financials as we run them, always assume that. So
Seems right to me too.
it would seem that we would be eroding the ability of the applicant to essentially make money if we were to include construction period in the life of the license. Plus, there's safeguards relative to delays elsewhere in the statute that would allow us to, press on making sure that construction period doesn't get, out of hand. But I wouldn't see how we could impose that restriction by including it as part of the license.
No, I don't disagree with that. I mean, that's economic sense. That makes good economic sense. But
You got me there for a minute, too.
Yeah, but
Yeah, I had me there for a minute. But
you woke up
it
on the wrong side
seems
of
to,
bed today.
seems to me that we need to think about a condition with respect to payment of commission fees then.
Yes.
And that's got to be a special condition. Because they're not a licensee.
That's right.
The assessment,
Because
you're
they're not
referencing
assessment.
assessment, that is in there, that they have to pay the assessment.
Right.
We have in, it's condition number 5.
Yes, but
That references the
that-
sessions
that-
under 121.
so the license is issued, but the term doesn't begin until construction is complete?
But
Is
they
that-
s-
So we're bifurcating the license issuance and the commencement of the term of the license?
Yes,
Okay.
that's right.
Fair enough.
Yep.
The term
I'll
wouldn't
go back
start
to sleep.
until
Thank you.
operational approval.
Yes, that's right.
Right.
But the assessments would start right
Gotcha,
away.
gotcha. All right.
Anyway. I would ask the commission to keep in mind that we do have to define gaming establishment for the successful licensee.
Right.
So just kind of keep that
Right.
in the back of your mind when you deliberate.
Right.
Is that a statutory requirement? What do you mean we have to define a gaming establishment?
Well, gaming establishment is a term, and then
Right,
other
it's
things are
defined.
triggered by it. So we would want to define for the successful licensee what the gaming establishment consisted of.
Beyond what's required in the statute?
Well, it may be in meets and bounds.
Yeah, it could be meets and bounds, if there are certain phases, for example, like if there's a hotel, but it's coming down the road and that's part of the gaming establishment, you would want to include that now.
how long would you estimate in your mind's eye between the vote to award, which is the award, and the execution of this document?
A couple days. I mean, I think it would be fairly quick. We would be adding some things. I know the successful licensee would want to look at it. The commission would need to review it as well.
Right. Okay. Okay. Anything else?
That's it.
That's it.
On item 5? So patiently waiting. Region B, impacted live entertainment venue petition, the Big E.
Good afternoon, Chairman Crosby, Commissioners. The issue today is whether Eastern States Exposition is an impacted live entertainment venue relative to the MGM Springfield development of a resort casino. And today you could decide whether to accept or deny ESC's petition based on the conditions provided in the statute and regulations. And just to recap, the question is whether the venue meets the definition as set forth under Chapter 23K, Section 2, a not-for-profit or municipally owned performance venue designed in whole or in part for the presentation of live concerts, comedy, or theatrical performances, which the commission determines experiences or is likely to experience a negative impact from the development or operation of a gaming establishment. Under the regulatory definition, the commission is to consider factors including but not limited to the venue's distance from the gaming establishment, the venue capacity, and the type of performances offered by that venue. And also, the commission will consider whether the applicant intends to include a geographic exclusivity clause in the contracts of entertainers at the proposed gaming establishment, or in some way intends to limit the performance of entertainers within Massachusetts. So, in Eastern States Exposition, I'll call them ESC's I Love petition, they focus on agreements with existing venues, the Mass Convention Center Authority, the owners of the Mass Mutual Center, and an agreement with the City of Springfield through their host community agreement, an agreement with MGM and the City of Springfield to underwrite a specified number of events at Symphony Hall and City Stage.
Do you remember how many of those are?
Yeah, so MGM has agreed to program 4 events at the Mass Mutual Center and 3 events at Symphony Hall and 3 events at City Stage, all of which are municipally or state-owned facilities, existing facilities. In ESC's petition, they indicate that their ability to host top act entertainment performances would be restricted. They're concerned about limitations and restrictions prohibiting entertainers from performing with a certain radius. And they're concerned that they will be forced to compete with and be unable to secure and contract with top quality entertainers at their venue. You may recall that an HLT analysis determined that overall ESC does not qualify as an ILEV or an impacted live entertainment venue, that rather 2 particular venues within ESC could be considered because those are the 2 venues that during the 17 days of the fair program live entertainment, Xfinity Arena and the Coliseum. So during the February 18th commission meeting, you gave Eastern States Exposition and MGM more time to see if they could come to an agreement regarding the I Love petition. And although both parties communicated over the weekend, no agreement was reached. And I recognize that the substance of negotiations are not supposed to be part of the final determination. But in this case, both parties requested that you be provided both the emails and the agreements that were communicated over the weekend. So in your packet, there are several offers, including one titled ESC's Revised Offers to MGM dated January 22nd. And then MGM's executed offer to ESC dated February 20th, and it's redlined against their original January 17th offer. Did you want me to get into some of the details of the negotiations?
It'd be helpful if you just summarize the
Okay.
the progress or lack thereof.
Okay. So I think it comes to this. MGM believes that the Chapter 23K Section 2 statute contemplates a negative impact from competition at the gaming establishment and not competitive impact from a company's support of other local venues. And so they're are interpreting the statute and the definition, they contest that ESE is an ILEV. They indicate that they are willing to co-promote, and they have agreed to some of ESE's requests in their original negotiations. They've offered to co-promote ESE's venues through their website, social media, other marketing channels, and they clarified that. They, however, are not willing to provide ground shuttle transportation to ESE, between ESE and MGM during the 17 days of the fair. They did not agree to co-promote to the motor coach industry. And I think this probably is one of the larger sticking points. They did not agree to sponsor and co-promote two entertainment performances, one during the Big E and one outside the 17 days of the Big E Fair. Additionally, and I'm summing it up now, MGM indicates that they have not extended the restricted the programming restriction at the venues, as HLT suggested, 45 days before the Big E and 30 days after, for 3 reasons. The main reason I think that they list is that it would impact their prior contractual relationships with the owners of Mass Mutual, Symphony Hall, and City Stage that require that they program a specified number of events throughout the year. So I might just stop there and see if you have questions. I should add that both parties are here and are willing to clarify or answer any questions should you be interested in that. HLT is also here, should you require clarification from their summary.
Well, let me ask a question to make sure we're all on the same page for starters. We gave another week in the hopes that the parties could make this determination themselves, come to an agreement themselves. They have not. I think, therefore, the question before us is not to mediate the terms of an agreement, but rather to determine whether or not ESC is an ILEV.
Right.
And, not to push the parties to go further or not farther, or to clarify those positions, but to determine whether or not they are an ILEV.
Mm-hmm.
Am I right? Does everybody agree with that?
Yes.
That's where we're at? Okay.
Yes.
Okay. Anybody want to start? I mean, I've got some questions, but
I was ready. Why don't you start with the questions, because I have
some
opinions.
answers?
I have opinions.
Well, I just was going to ask you to sort of re-summarize why you concluded that ESC was not an ILEV, and help me tie it carefully to the language of the statute.
Sure. We determined that ESE, the exposition and the fair did not constitute an ILEV because it didn't meet the definition of a performance venue for concerts, comedy or theatrical performances. That there were in fact.
So it's not a performance venue because
The fair itself and the exposition grounds that includes some 40 buildings do not meet that definition, but 2 buildings on the site, the Coliseum and Xfinity Arena, do meet the definition
of ILEVs.
of an ILEV from the point of view of proximity to the casino and capacity. But then it comes to.
Okay, so let me just, if the old Wang Center, now City Center, which has several venues within it, but that is the entity, the contracting entity, the parent corporation entity. If they were claiming status as an ILEV, but it was because of one of their 2 or 3 venues would be impacted, would you say the City Center is not a ILEV by extension here, by the same logic?
I'm sorry, Mr. Chair, I'll admit I don't know the building that well, but my sense is that the focus here was on specific performance venues with an entrance and egress that put performances on stage for the benefit of the audience in that contiguous building. And that's the view and the definition that we used going forward. And therefore, from a proximity and a capacity point of view, those 2 structures on the ESE grounds meet the definition. The third part of the definition, though, is programming, and the focus there is on comedy, theatrical, or concert events. In our view, only through the 17 days of the fair are those buildings used to stage those types of events. And because MGM has effectively mitigated 100% of that by saying they would not put events on in the buildings they have an arrangement with during the fair, we didn't see any negative impact. And therefore, rather than suggesting that the 2 buildings were an ILEV for 2 days and or determining they're an ILEV because of 2 weeks, we've determined they are not an ILEV because the only 2 weeks where they qualify or meet the definition, the applicant has mitigated the negative impact.
Is that doing the job right? I mean, the question is, are you an ILEV? And are we to take into account pieces of the negotiation that may or may not adhere, or is that overstepping our interpretive bounds? It sounds to me, this is a question, not a rhetorical question, it's a question. It sounds to me like you can be you're saying these 2 facilities would be an ILEV, except that somebody has agreed that they won't operate during those, and therefore they're not an ILEV. But that sort of feels like cherry picking from the negotiations in advance.
Mr. Chairman, just to clarify, Commissioner Zuniga, if it was the run of the year where we were making this determination, it would be, I think, different than the fact that it's just the 17 days. So by definition, that these buildings are operating for special purposes for a short-run event, and the fact that the applicant has mitigated the impact on that event. We looked at that, HLT looked at that differently, than if the buildings were used throughout the year for these competitive purposes, and that there was a blanket commitment given for a much longer period of time.
The definition says.
Yes, it's the definition.
Sorry, you're going to go there?
I was going to go to the definition.
Go ahead.
It experiences or is likely to experience significant impacts. So if in our view, the commitment from MGM makes it such that we believe it's that the biggie, actually, the two venues are not likely to experience significant impacts
Because of the commitment that's.
because of the commitment that's made. Then it wouldn't meet the definition on that side.
Is that
It's
reading
all, it's,
with what you-
It says a negative impact, not a
Yes.
significant.
Yeah.
Any negative impact.
yes.
But yes, that corresponds with my reading. There would have to be a condition. I mean,
Yes.
they could renew, if we went that way, they could renew the petition if MGM didn't keep the
Right. okay.
competitive stuff out.
So,
But they've made a commitment to do it.
so you then went on to say the other day that, that probably the 17 days wasn't enough to get to the read that these two commissioners are getting in the statute. It would require not only a blackout on those 17 days, but some other considerable blackout, and you threw out different numbers. I thought it was 30 and 15, but I guess it was 30 and 45. So given apparently that those are not agreed to, what does that say about, in your view, whether they're an ILEV or not?
It would be ideal if there was a buffer period before and after the 17-day event, and I still believe that. Again, I think it comes down to the quantum of negative impact that can occur over a given time. And I think what the applicant has said, in good faith, is that there'll be nothing during the event, and that nothing during the 17-day fair, and that any events before or after would be minimized. My suggestion still would be that that might be something that the commission might consider making as a condition of the license, but it's the 17-day fair that is the main focus.
I was on the side of the later part of the definition, the legal framework on page 3, which is essentially what MGM argues
Page 3 of which?
of the
Of 4?
6,
6? Oh, thank you.
the petition. And I'm focusing specifically on the words development and operation. MGM is supporting these existing venues and is neither developing, as in building, nor operating the events that they promise to their host community. They're underwriting and they're promoting, but not operating. My read of what's behind this in the statute comes from the construction, the restriction on the number of seats that that any one of these venues can have, and further the definition here. I always equated development to actually construction. If MGM was taking over the Mass Mutual Center, for example, because it made business sense, then they would probably be either developing or operating, maybe operating for sure, or perhaps developing. But my read is that they're not doing any of those. That the concern, which is a legitimate one for the Big E, emanates from their underwriting, which in my view does not meet this definition of other venues, for the benefit of, in great ways, the host community. They're trying to develop the center of Springfield and support other assets of the Commonwealth. So I'm satisfied with the commitment that they do not program anything under those 17 days, and I don't see them as an ILEV because of this latter part of the definition. They're neither developing nor operating.
Well, they're developing or operating a gaming establishment. They're not, I mean, clearly part of the development of the gaming establishment is, among other things, the negotiation of the HCA. That's part of the development of the gaming establishment, I would argue.
As it pertains, well,
It doesn't say develop or operate a competitive theater. It says development or operation of a gaming establishment. So it's sort of their full, you know, their full plan of operation, everything they do, developing and operating a gaming establishment.
well, my read, in conjunction with the restriction on number of seats, is to protect venues as it pertains to what the applicants do on that same realm, developing and operating theaters, for example, or other venues. But
Anybody else?
I agree with HLT's conclusion that the 17 days will not, the likelihood of a negative impact is relatively small, and thus, I agree with their assessment that for that reason, they are not, they recommend we don't deem them an I-11. I find their work to be, to make sense.
I take a look at the statutory definition. A not-for-profit or municipally owned venue designed in whole or in part for presentation of live concerts, comedy, or theatrical performances. I suppose one could conclude that the entire grounds is not, I believe, and this is retreating to an important concept that sometimes is trivialized. I don't believe that ESE has satisfied its burden of proof that those venues, that component of the venue, is likely to experience a negative impact from the development or operation of a gaming establishment if MGM adheres to its 17-day blackout, which I would make, if we award a license to MGM, a condition of that license.
Do we have the authority to add some of the time that HLT?
We do.
Would that not be a good idea? I mean, if HLT is saying they're, to be fair, I guess, they're saying they think it would be best if there were X time added to that 17 days.
Well, it seems to me we ought to do that in the context of the license award to MGM.
this is,
And I think this is, I look at this as, well, I guess I can't, can I? Given what I just said. Consistency, damn it.
Yeah.
I don't know that 17 days, I don't know that we've got the I don't know that we've got the foundation to make that judgment. I'd like to pursue it further. I'd like to think more about it. But at a minimum, the head-to-head competition is something that I think is what would create a competitive disadvantage.
Right, and to,
Right.
but to make, you know,
I hear you.
yeah, I mean, if it was the day before and the
Right.
day after, that
Right.
clearly would have
Right.
some
Right.
impact. If it's a
Right.
week, it's less, a month, you
Right,
know.
right.
There is an important word here. This says, designed in whole or in part for the, which the commission determines experiences or is likely to experience, suggesting that we can reopen this. You can't experience until you're in operation, so clearly this gives us the authority to make an ILAB designation ex post facto. And whatever designation we come up with now, all or partial or no ILAB, I think if there were data that suggested later on that this maybe does have more of a negative impact than we had thought, or less of a negative impact than we had thought, we can reopen this.
Is that what the statute says?
Yeah,
Well, since it says experiences,
right.
Yeah.
In the present tense.
And the Community Mitigation Fund would not have us have the ability to distribute funds to other than surrounding or host communities, correct?
I
Not
believe
ILABs.
that's correct, yes. Yes.
That's an important point, though. I hadn't seen that. That's a very important point.
right, that we could open it later. We get another bite at this apple for whatever decision we make.
I've wrestled with this because, you know, certainly in my mind, the first part, actually, a bulk of the definition, I think, you know, here again, maybe the legislature didn't anticipate every wrinkle we would come up against, but, you know, the ESE, not-for-profit, whole or in part for the presentation of live concerts, and those are certainly the draws the nights I've been there. You know, short of, you know, again, kind of placing into a condition at some later point what we've heard from the applicant they would agree to lessen the impact. I wrestle with how I wouldn't designate them based on something that is in the application or is a condition, potential condition of a license to come later.
I'm sorry, just say that again?
The justification being made by the applicant is, you know, their willingness not to book anything during the 2-week window. And we obviously have our consultant who's suggesting a longer window, which from the documentation may not be amenable to the applicant. Somehow giving some basis to that measurement, and again, maybe this is me just wrestling with it, having to come up later in the condition of the license. Short of that, I'm not sure how I can not suggest that they are an impacted live entertainment venue.
Well, I totally agree with that. I mean, to me, it is, until you get to the window of the 17 days, it is an island. To me, you know, in whole or in part, as you said, covers that part from my standpoint. What the other commissioners are saying is the fact that window has already been taken away means that the likely to experience a negative impact is, according to our consultant at least, substantially modified, if moderated, if not eliminated. And that feels a little funny to me. As I said, it feels like you're kind of cherry picking pieces of the debate, but I think the consensus here is, you know, it works within this language. So I'm with you, but now they're saying, okay, let's at least do the 17, and maybe let's do 17 and change on either side.
Right.
And at that point, particularly since you can reopen this later on, a year from now, or whatever number of years from now, to take a look at it and see what's going on, that, you know, maybe that's the appropriate.
Well, I appreciate the fact that we think that we can reopen it, and, you know, obviously, I think there's more to come on this subject as we move towards if this applicant is issued a license, that it has the opportunity to become a condition of the license, I guess.
Right. Well, it seems to me that there ought, I mean, it's somewhat arbitrary, but it seems to me there ought to be some, you know, we ought to add something onto the window itself, onto the 17 days.
No, let's not forget that it's not because the MGM is not amenable. They have made commitments with the host community relative to other timeframes. So,
Well, yeah, that's a good question. I didn't understand that. Maybe somebody can tell us why you've got 10 events, I think, that you're committed to. What in those commitments makes it impossible for you to add time to either end of the 17 days?
Thanks, Chairman. Chad Nozel, representing Blue Tarp Redevelopment and Field Resorts
Speak to the
International.
mic, please.
Thanks. To go back to your answer, you're referring to essentially one of the portions of the company's agreement as part of its host community agreement. It agreed to program certain events at various venues around the city. We talked about that, Mass Mutual, as well as City Stage and Symphony Hall. It's 10 events, and I believe there's an option for, I think, an additional 2 under that agreement, so it's a total of 12. So what we feel is happening here, that agreement was negotiated certainly, I believe, back in the end of 2012 for the purposes of that programming. And we feel by adding anything to the 17 days, you're going to materially impact our ability to meet those commitments. And we already have challenges, certainly, to program those events. And as you take away, essentially, time where we're able to meet our commitments to those venues, it hurts our ability to meet what we negotiated in good faith as part of our agreement with the City of Springfield. So you're talking, the consultant here is talking about adding potentially 87 days for which that time period would go. We would then be forced to essentially now program 12 events within a less than 9-month period.
Well, you're forced
That's
to,
not
you're,
what's...
you're
that's-
forced to do 10, not 12. You have the option of 2 more.
Additional event commitment, paragraph 3, that we've agreed to 2 events per calendar year at either of those, at any of those venues.
I mean, it seems to me, I mean, if you added a day on each side, that would not be a big deal. If you added 100 days on each side, that would be a big deal. So there's some distance between 1 and 100, which would do something, in our consultant's view, to further mitigate the impact on ESE without doing too much violence to you all. And, short of throwing a dart, I'm not sure how you come up with that, but it does seem to me that under the peculiar circumstances here, adding some material amount of time to the 17 days, it makes sense.
But whose burden?
The other side wants to.
They should, now they should have an option.
Sure. Respond. Yep.
Thank you. Mark Kress, appearing for the Eastern States Exposition. I think, Commissioner, some of your earlier comments, you have it right. And I think the most important point that needs to be made here is this issue goes back to the first issue on the agenda. Process is important. Under the process envisioned by the statute and regulations, if the Eastern States Exposition is determined to be an ILEV, which I think everyone has acknowledged now, and I'll use the example, but for MGM saying that it will not compete during those 17 days, if it had a major event right in the middle of the Eastern States Exposition, I think everyone's acknowledged Eastern States or the venues would be an ILEV. If that being the case, the process isn't the applicant saying, okay, we'll black out these 17 days and we'll disregard everything else that the Eastern States Exposition asked for in these negotiations, which were made part of some paperwork that was floated, and have the commission endorse it. If, in fact, Eastern States Exposition, it's an on-off switch, Commissioner. You said it last time. You either are or you aren't. The position of the Eastern States is that in the words of Mr. Cassidy on the drive here, it was inconceivable that, that the eastern states would not be determined to be an ILEV. So the process, that being the case, the process under the statute and regulations is that there is an additional 30 days to negotiate an agreement, and after that, there's an arbitration process. That is the process and the protocol under the statute and the regulations. It's not to allow an applicant to pick and choose what's acceptable to it, proffer an agreement and say, okay, they're protected. We don't believe, and the correct amount of days is 92 days, 30 and 45 at or 45 and 30 at the beginning and end of the exposition. The reason why we are where we are is we're still concerned, even if there were those blackout dates, that MGM would figure out, being the business that it's in, that there are 1.5 million people going through that venue during that period. 80+%, it could be as much as 85 or 86% of the entire exposition's revenue is during that 17 days. Even a small portion of, if that were impacted, literally the survival of the exposition is in jeopardy. It's that important. We are not trying to, and that's probably the most troubling part of this whole process. Eastern States Exposition is not the bad guy here. These are not-for-profit people trying to protect an institution, a 100-year-old institution. And the way MGM has handled itself throughout this process is really troublesome.
Well, how is Eastern States Exposition likely to experience a negative impact from the operation of the gaming establishment if the gaming establishment blacks out the Eastern States Exposition dates?
Well, again, Commissioner, I apologize if I wasn't clear. That's not the point.
I believe it is. So my question to you is a factual one. How, and I accept your disagreement, but assuming that I'm correct, how is Eastern States likely to be adversely affected, negatively impacted, if MGM has a blackout during that 17-day period?
Well, I think the Commission's own consultant agreed that there's some time period before and there's some time period after, at a minimum, in order to protect the Eastern States Exposition. And for instance, people planning on coming, from everywhere in New England, if they plan around, a big event at one of the MGM venues, either before or after, that's a loss of a customer, a loss of a paying recipient to a potentially competing event. And one final point, the subject matter of the negotiations and the approach Eastern States tried to take in these negotiations is, let's get these folks involved. Let's get them to have a vested interest in an event during the Eastern States Exposition, so that the likelihood of them competing against themselves is diminished. Vested interest. And now that's being thrown back at us. Well, that's not acceptable, and the blackout after, we're only going to give you 17 days. And once again, for the record, I just feel that that is extremely important. That's not what the statute and the regulations contemplated. And, I think it's safe to say that, the Eastern States Exposition begs you to please protect it.
Excuse me, did you have something else you wanted to add, or were you?
I was going to try to cite an example as to how it could be affected in the entertainment industry.
Gotta come up and use the microphone.
I'm Gene Cassidy, and I'm the president of the Eastern States, and I appreciate the opportunity to have this moment to address you. I don't want to get into the weeds because it's a complicated business. The entertainment is very complicated, and I was going to offer an example of how we could be sort of shut out of the business. And what might be the most easy thing to understand is, for example, if both MGM and the Eastern States were vying for a particular named talent, MGM certainly has much more capacity to pay talent than the Eastern States does. They also may have a more attractive indoor venue than the Eastern States does.
But they don't.
Well,
they are committing to underwrite the Mass Mutual
I think.
and other venues.
I think we're parsing words. You know, they have access to venues, and I think that's really the point. But aside from that, we're competing, say, for the same talent. And MGM decides to advertise that talent because that talent's going to come to visit them, say, in December. And Eastern States has booked that talent in September. It completely takes the wind out of our promotional sale if our potential customer has an opportunity to see that individual in a better location or a different location at a time either after the fair or before the fair. It takes the allure of presenting that famous person out of the promotional marketplace. And that's why I believe that the consultant would have suggested, as he did, 45 days prior, 17 days during, 30 days after. But frankly, that's not even enough. It's something, but it's not enough. And my goal really was very, probably naively, try to work out an arrangement whereby the two of us could be vested as partners. But I was rebuked at every time. I have, as of right at this moment, had more face time with you commissioners than I have had with MGM.
So is it a question of getting us to clear the 14-day window or 17-day window of the fair? Is it a request to have the two of you figure out who gets what act in during the year? You just talked about, we're worried about competing for
Again,
Def Leppard or whoever else. That'd be my preference. But coming in at the beginning of the year is as opposed to the reference. I mean, as opposed to the blackout window.
Yes, Commissioner, that would be very helpful. In the equation, that would be very helpful. To date, I've not seen any willingness on the part of our friends to have any even constructive dialogue about that very topic.
But didn't they forward an agreement that, wasn't there some document that was forwarded by MGM relative to some of these conditions? For example, this restriction, the supply side restriction, they're willing to abide by it.
Well, there is. I'm not an attorney. I'm a trained public accountant by profession, but the fact of the matter is that's all predicated upon their being able to, it's at their discretion. And if they were to err, if they were to make an error of omission or intent, there was no recourse. To me, that just seemed to be an empty promise.
Well, that's something that we could clearly put in some of our conditions. I mean, if anybody has recourse here, is us, correct? When we regulate the applicant.
I have I'm obviously wishy-washy on the point, but it does feel, I said it feels funny to me that for us to negotiate the terms under which it is not an ILEV, or the terms under which the ILEV status in effect is mitigated, that I don't know whether 17 days does the job or not. And I mean, we have an informed opinion from a consultant, which he somewhat committed to, but not absolutely committed to. I wouldn't know what to put in there for time. And it seems to me that the process here is for us to pre-negotiations, pre-variables, to make a determination, if they can't agree themselves, about whether there is the potential for a material adverse impact. And that the answer to that is yes. Whether the 17 days takes that away or not, even though our consultant said to a substantial extent it does, I don't know that. And it seems to me that we would be better served by having the two parties have to hammer it out. And then come to, well, then they go to arbitration.
Well, that's
Chairman,
assuming that
I'm sorry.
we're disagreeing with our consultant's
Yeah,
recommendation.
that's what I'm saying, so.
Yeah, I
So
don't,
it's not
Can
the
I-
potential
know.
for, it's the likelihood of. And that's not just words. And I just thought it helpful to point out those are the words.
Yeah.
And somebody's got the burden, and as I said a minute ago, I don't think the burden's been met.
But you don't think the burden has been met because of the parties, because of MGM's willingness to put the 17-day window? And I just don't have enough knowledge to know whether that's true or not.
It's likelihood, and I would agree with Commissioner McHugh that the burden has not been met. And our consultants have served us well, and I believe they have in this case also with the recommendation.
But you're the first person to say let's not delegate everything to a consultant, you know.
We're not delegating, we're deciding whether or not what they say has merit, and I believe it does.
Well, I think it has merit. I'm not dismissing the work. I mean, I think even the consultant met some mets on this issue, and considers it a gray area, and so do I. And so I think there's a better process for resolving the gray area than to have us put a stake in the ground, either at 17 or 17 plus some arbitrary number that we come up with. So that's just my own opinion. Any more thoughts?
Did you want to add?
I understand, today wasn't to come back and rehash exactly, what we have already presented, I think, to the commission. The record that is before it for purposes of making this determination. We're certainly, comfortable in the way that we've approached this issue. We've attempted in good faith to put out offers to resolve this within the context of what the impacted live entertainment venue statute and regulations could possibly contemplate. What we're talking about here today now is some sort of potential absolutely hold harmless from any competition in the marketplace. It's not what was intended. It goes back to what I believe Commissioner Zuniga described as the supply side. We've addressed that. There is no impact. The Commission's consultant have said that there's not a negative impact. The record before the Commission is clear, and that's what this decision needs to be based on.
I don't think the consultant said there's not a negative impact. It was a little softer than that, but we've all heard it.
And again, this is for the record. The only reason there is no negative impact is because MGM has chosen to assert that there isn't because of this 17-day blackout. It is an ILIF.
We dispute that for many of the reasons that the Commission has talked about. They don't meet the statutory definition. This is a venue that was not contemplated when it comes to dealing with these particular issues and this particular statutory structure.
All right, so this is one we have to make a decision on.
Right.
Does somebody want to make a motion?
Sure, I can. I would move that this commission do not designate the Eastern State Exposition as an island based on the information presented before us and the discussion we've had amongst ourselves.
With the 17-day blackout?
Yeah,
Condition?
yeah. Well, we could easily.
Are you saying just not an island, that's the end of it? Or are you saying that with certain conditions, it's not an island?
Well, the way I understand it and the way it's been before the record here, to me that the fulcrum has been is likely to experience a negative impact. With the commitment that MGM has made relative to this 17-day blackout, I don't believe that the grounds are likely to experience a negative impact. So it's with everything else, with the commitment they've made. We could make that a condition at a later time. We could reopen it, as you suggest, if we find out in the future that this impact, this forecast didn't turn out to be the case.
Well, would you accept an amendment to that motion that said, provided that MGM adheres to its 17-day blackout and without prejudice to the Eastern State Exposition's right to repetition the commission in the event that it experiences a negative impact from the operation of an MGM-controlled venue.
Yes.
Second.
Further discussion? You know, I would just say that I think, as you want, you can make the point that if 17 days matters, 18 days matters, probably 19 days matters, probably 20 days matters. I don't know whether it's somewhere between 20 or 180, you know, and so to pick 17 clearly does not do the job in my judgment. And I don't think we have the wherewithal to pick a number.
I come back to the argument, I don't think it's the 17 days that matters. I think it's the ability to compete for the talent that each side might pursue.
And so how does that cut? Which?
I don't want to amend the amended motion.
All right. Any other discussion? All in favor of the motion to determine ESE as not an ILEV, subject to the amendment of the 17-day commitment by MGM and a no prejudice to the option of reopening if ESE at some point feels it does experience, I guess, or for that matter, is likely to experience a negative impact. Please signify by saying aye.
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 Opposed?
No.
The ayes have it, 3-2. Okay, thank you. I have one more quick break to take. I will be right back. All right, we have one other item, which is the other business item, which we reserve, in this case. We love that you folks are talking, and please keep it up, but somewhere else. This is reserved for matters which the chair didn't have a chance to anticipate prior to setting the agenda, and that is the media report recently about the expenses of the commission. And I think it's important that we take note of that and talk about it a little bit, make sure that A, the public knows what we're doing, and B, that we are doing it properly and well. There are two important points that we do want to emphasize, and we've said in our statement, which is one, that no state money, no taxpayer dollars will be used for any of the commission's expenses ever, unless the legislation is changed. We are borrowing money from the rainy day fund for some of our initial operating expenses. That will be repaid completely by the license fees from the applicants. The second is, I for one feel quite confident that for the very most part, the expenses are appropriate. Each of the things that sometimes sound a little bit extravagant, many of them have logical, rational, acceptable explanations. However, we know we are a fast-moving, fast-growing agency. We have some forms and standards in place. We need to review those. We need to be more careful. We are in the public eye, and appropriately so, and we will have these kinds of assessments made from time to time. We have already suggested, not already suggested, but committed to having an outside third party come in and help us take a look at comparable agencies. This is an idiosyncratic agency with unusual demands for expenses, particularly the investigatory expenses. But it's important that we understand what the standards are of other comparable agencies who do similar kind of work across the country, and that we are in conformance with the best practices of those agencies. So, I mean, it is at its bottom line constructive criticism, and we take it seriously, and we will look hard at our policies. There's a lot of work going on already with our new Director of Finance and Administration, but we will take a special step to address these issues and to review them by an outside party. So that's what I wanted to say. If anybody else wants to speak to any of this, now is the time.
Well, I would just like to echo a couple of things. Number one, for me, it's not as important that this is not state money. We have an obligation, and I know we all share this, to spend whoever's money wisely, and are bound and determined to do it. Secondly, we have committed to an independent review of our policies. We need to look at the policies that we have in place now. Those policies were created at a time when we were 7 or 8 people, and operating long before we got into the investigatory phase of our operations. And we've now grown to 50. We are finished the first round of the investigations. And it is inevitable that the policies that ought to apply to this organization in its stage and its activities now are different from those that we had in place when we weren't doing any of this stuff, and simply trying to get the basis for hiring and getting people aboard who could do the work that the commission needs to do. So I echo the fact that we need to carefully look at what's happened. We need to carefully look at the policies that we have in place. We need to get an independent review of those policies. We need to get to a stage where we are able to post all of our financial information routinely and regularly, so it's available to all citizens of the Commonwealth. And we need to get there as quickly as we possibly can. We're in the midst of doing a number of things, but and always you try to prioritize, and events like this tend to be a wake-up call for perhaps the reordering of priorities. So we need to do it. We need to do it quickly. We need to do it promptly, and I'm confident that we will.
I agree, and the only thing that I would add to that is not just look at our policies, but certainly our procedures and the implementation of those policies and how they have evolved, and perhaps now need to evolve yet again as we grow and have departments that grow, and it's no longer just 1 or 2 people, but there are more people that report up the food chain, etc. It's something that needs to be looked at continuously, and I think this is a good opportunity for us to take a hard look at all of that.
Another important piece is that everyone understand what the procedures are. I think that there's probably some, one of the things we probably haven't had the time or taken the time to do is enough training when it comes to what the procedures and policies are. And with a new CFAO, I think it's the perfect time to review, amend, and then make sure everyone understands what the procedures are.
And I would like to just perhaps add a fine point to some of the remarks earlier. All of our costs are available through different venues. We are an open checkbook. We've always been from the beginning by virtue of using MARS. Sometimes the way, because MARS is a standardized system, sometimes the detail of those expenses are difficult to ascertain, but not impossible. And we have a lot of breakdown and detail behind that's available. That's the piece that we should be a lot more diligent in providing to the public, but also to this commission on a regular basis. That's something we should do as well.
Anybody else? Anything else? Nothing? Do I have a motion to adjourn?
So moved.
All in favor?
Aye.
Aye.
The ayes have it unanimously.